Ever heard the phrase, the straw that broke the camel's back? Well, in the legal world, sometimes it's the argument that tanked the entire case. Today, we're diving into a fascinating, almost unbelievable story about how one seemingly clever argument completely backfired on a lawyer, leading to a disastrous outcome for their client. It's a tale of high stakes, courtroom drama, and a lesson that every aspiring lawyer should take to heart. So grab your popcorn, because this story is a wild ride. Picture this: a high-profile personal injury lawsuit. On one side, you have a plaintiff. Let's call him Mr. Smith, who was seriously injured in a multi-car pileup on the highway. He's suing the driver of the truck that allegedly caused the chain reaction. On the other side, you have a massive trucking company with an army of expensive lawyers. The company's lead lawyer, let's call him Mr. Jones, was known for being aggressive, sharp, and a little too confident for his own good. The case was complex. There were multiple vehicles involved, conflicting witness testimonies, and a whole lot of finger-pointing. Mr. Smith's legal team methodically built their case, presenting evidence that the truck driver was speeding and not paying attention, causing him to rear-end the car in front of him and setting off the domino effect. They had accident reconstruction experts, eyewitnesses, and data from the truck's black box. It seemed like a solid, if challenging, case for the plaintiff. The trial went on for weeks. Mr. Jones, the defense lawyer, tried every trick in the book. He tried to discredit the plaintiff's witnesses, poke holes in the expert testimony, and paint Mr. Smith as a careless driver himself. But the plaintiff's team was prepared, and they held their ground. As the trial neared its end, everyone in the courtroom, the judge, the jury, the observers, felt the momentum was shifting in Mr. Smith's favor. The evidence was just too compelling. It looked like the trucking company was going to be found liable and would have to pay a significant sum. Feeling the pressure, Mr. Jones knew he had to do something drastic in his closing argument. He needed a bombshell, a Hail Mary pass that would completely change the jury's perception of the case, and he thought he had one. This is where things get interesting. So for his grand finale, Mr. Jones decided to unveil a brand new, never-before-mentioned theory. He stood before the jury and, with all the dramatic flair he could muster, he declared that the real cause of the accident wasn't his client's truck at all. No, he argued, it was a phantom vehicle. He painted a vivid picture. Mysterious, unidentified car had supposedly swerved recklessly in front of the truck, forcing the truck driver to slam on his brakes. This phantom vehicle, he claimed, was the true culprit. It had appeared out of nowhere and disappeared just as quickly, leaving chaos in its wake. The truck driver was not a negligent speeder. He was a hero who reacted defensively to a sudden, unforeseeable danger. It was a bold move. On the surface, it might sound like a plausible, if convenient, explanation. Shifts all the blame to an unknown, untraceable party. The problem? There was absolutely zero evidence to support this theory. Not a single witness mentioned a phantom car. No police report noted it. The accident reconstruction didn't account for it. Mr. Jones had literally just made it up for his closing argument. He was gambling that the sheer novelty and drama of the story would create enough reasonable doubt in the jurors' minds. At first, there was a stunned silence in the courtroom. The jury looked intrigued. Mr. Smith and his lawyers looked shocked and confused. Had they missed something? Was there some piece of evidence they were unaware of? Mr. Jones was feeling pretty pleased with himself. He thought he'd planted the seed of doubt that would save his client. He was wrong, terribly wrong. When it was the plaintiff's lawyers' turn for their final rebuttal, they didn't panic. Instead, they walked calmly to the podium. The lead lawyer, a seasoned veteran, let's call her Ms. Davis, looked the jury directly in the eyes. She didn't attack the phantom vehicle theory head-on. She didn't need to. Instead, she did something much, much smarter. She started by saying, "Ladies and gentlemen of the jury, for the past 3 weeks, the defense has told you a story. They told you their driver was careful. They told you the expert witnesses were wrong. They told you my client was at fault. They presented their evidence and their arguments, and we presented ours. But just now, in the final moments of this trial, they told you a completely different story. A story about a phantom car." She paused, letting that sink in. Then she continued, "The defense has spent this entire trial trying to convince you of one version of events. But now, when it seems that version isn't working, they've suddenly invented a new one out of thin air. A version with no witnesses, no proof, no evidence whatsoever. It's a ghost story told at the last minute, because they know their real defense has fallen apart. And then came the killer blow. Ms. Davis said, "Ask yourselves this. If the defense truly believed their own original arguments, if they truly believed their driver was not at fault based on the actual evidence, why would they need to invent a ghost? The fact that they are resorting to a desperate, last-ditch fantasy about a phantom car tells you everything you need to know. It tells you that even they don't believe their own case anymore." Boom. The entire courtroom dynamic shifted in an instant. She hadn't disproven the phantom car theory. She had used the theory to destroy the defense's entire credibility. By introducing this unsupported, desperate argument, Mr. Jones hadn't created reasonable doubt. He had accidentally signaled to the jury that his entire case was built on a foundation of sand. He had essentially admitted, "My primary arguments are so weak that I have to make something up." The jurors' faces told the story. The intrigue was gone, replaced by looks of understanding and, for some, even annoyance. They saw the phantom car argument not as a plausible alternative, but as an insult to their intelligence. It was a cheap trick, and they saw right through it. The lawyer's attempt to be clever had backfired spectacularly, making him and his entire case look dishonest and desperate.
Nice.
The jury went to deliberate. It didn't take long. They came back with a verdict entirely in favor of the plaintiff, Mr. Smith, and the damages they awarded were huge, Evan, larger than what most court observers had initially predicted. Later, a few jurors spoke to the press. They confirmed that the phantom vehicle argument was the final nail in the coffin for the defense. One juror said, "Up until that point, we were still weighing the evidence. But when the lawyer brought up that crazy story, we all just looked at each other. Felt like he thought we were fools. Made us trust him and his client less." So what's the big takeaway from this legal disaster? It's a powerful lesson in persuasion and credibility. In any argument, whether it's in a courtroom, a business meeting, or a debate with friends, your credibility is your most valuable asset. Once you lose it, it's almost impossible to get back. Mr. Jones's mistake wasn't just that his argument lacked evidence. His mistake was that he violated the unspoken contract between a speaker and their audience. The audience in this case, the jury, expects you to argue in good faith. When you suddenly pivot to a wild, unsupported theory at the last minute, you break that trust. You're no longer seen as a credible source of information. You're seen as a manipulator trying to win at any cost. This story is a classic example of why lawyers are often told, "Stick to your theory of the case. You can't just throw everything at the wall and see what sticks. You need a consistent, coherent narrative that is supported by the evidence you have." Trying to be too clever or too dramatic can easily backfire if it undermines your overall credibility. In the end, a simple, honest argument, even if it's not flashy, is almost always more powerful than a brilliant lie. The tale of the phantom vehicle serves as a warning. Mr. Jones, in his desperate attempt to snatch victory from the jaws of defeat, ended up handing his opponent the win on a silver platter. He didn't just lose the argument. He lost the entire case because of one fatal, ill-conceived moment of creativity. It just goes to show that sometimes the smartest move is knowing when to stop talking. What do you guys think? Have you ever seen someone's argument completely fall apart because they tried to be too clever? Let me know in the comments below. It's a fascinating aspect of human psychology and communication. Thanks so much for watching, and if you enjoyed this story, don't forget to hit that like button and subscribe for more deep dives into incredible cases and courtroom drama. See you in the next video.